Are they important? And if they are, which are the most important ones?
All
Do you
right.
need them in non-contract? Hello?
Do
you need them in all contracts? I said earlier, you can hardly find a contract where there is no one boilerplate or the other. They raise legal issues. Some raise both legal and commercial issues. So what we tend to interrogate is their purpose in a contract, the drafting issues they raise, their location, examine some precedents, and also examine other commercial clauses. Now, what is the origin and meaning of boilerplate? The term boilerplate is used in the general sense to describe standard clauses usually found in written agreement, irrespective of the subject matter. Now, like I said earlier, they may not be necessary, but for instance, there is no contract that has no commencement clause. There's no contract. And commencement is one of the issues we are going to discuss today. Now, what is the origin of the term? What is the origin of the term boilerplate? It's suspected to have originated from the US, where, journalists, for instance, in a place like Abuja, you have a newspaper with a head office in Abuja that has correspondence in Lagos, Ibadan, Benin, Gombe, Onitsha, Port Harcourt. Now, you wonder, how do they receive their news item every day for publication the next day? Now, what they do is to have what we refer to as metal drums. The metal drums are only preset. So what the correspondents do, just fill in the metal drums and forward to their headquarters in a shape already typeset, ready for printing. That's how the discussions about boilerplate started. So the standard text is slotted into the newspaper. And like I said, that is how the concept emerged among journalists. With time, lawyers started using them. And so that's how lawyers started using standard terms, standard clauses in their contract. Some of our colleagues often refer to them as boring and unimportant terms. But I want to assure you that you should not disregard them in a contract. If you find them in a contract, you do not know the meaning, please try and ascertain the meaning. Don't disregard them, because these terms sometimes deal with the operational issues in a contract. For instance, the governing law of a contract. Now, when I was general counsel in BPE, we went to the UK to discuss, to negotiate a contract. We spent 4 days negotiating the contract. By the 5th day, it came to determination of the governing law of the contract. We spent the whole day trying to agree on the governing law of the contract. The problem I had was I was the only lawyer from Nigeria. There was a lawyer from the US, 2 lawyers from the UK, 1 lawyer from France, 1 lawyer from Germany. All the other lawyers said the governing law of the contract must be UK law. And I said, no, Nigerian law. And what are we talking about? We were talking about Aluminium Smelter Company at Ikotabasi in Akwa Ibom State. And I asked them, how can English law govern Aluminium Smelter Company in Ikotabasi? And what I do with negotiations, when it becomes tough, I go academic. I ask them, ordinarily, how do you determine the governing law of the contract? Let's leave this ASCON at Ikotabasi. Let's address the issue. How do you determine the governing law of a contract? And this is where I will advise our colleagues who have interest in international practice to have some background in conflict of law rules. Conflict of law rules. In conflict of law, you know the connecting factors. The connecting factors are the factors that connect a transaction to a particular legal system. Now, what are these factors? For instance, you look at the place where the contract will be entered into, or where the contract will be performed. If all else fails, you look at the legal system that has the closest connection with the transaction. So if you do not take time in negotiating this contract, you find that when there's a dispute, it will affect all your commercial obligations. So it's important that we know what they are and the fact that they can create problems. So as businessmen or advisors to businessmen, instead of focusing on the pure commercial terms only, these boring ones can create problems. For instance, entire agreement clause. If you ask me to review a contract for you, I will go and check whether the contract has entire agreement clause. I will discuss this in more detail later. And for those of us who followed the P&ID arbitration, you know that the problem Nigeria had, the main problem Nigeria had with that arbitration was the issue of seat of arbitration. The contract refers to venue of arbitration, but the tribunal took it to mean the seat of arbitration. So it's important you pay attention to all these clauses that appear less important and unglamorous. They will have effect on the main contract. So my advice is, don't leave negotiations to your lawyers alone, or what happens in some ministries, some directors will travel, go and negotiate a contract and come back and call director of legal services or head of legal and say draft. No, please ensure that you travel with them, because these boring clauses can create problems, and they do create problems. And they have strong legal elements. For instance, if you are negotiating a contract, several issues will arise. Like, should a party be allowed to assign its rights or obligations under the contract? Now, COVID-19 was unforeseeable. So if events like COVID-19 arises, can any party be excused from performance? When you are negotiating, do you provide for litigation or arbitration? And you know, negotiations can take as long as 1 year. In the course of this, several representations have been made. In some cases, there are pre-contractual documents signed, like MOU. Now, when you sign pre-contractual documents and you eventually draft the main contract, some representations in the pre-contractual documents are not in the main document. Our party is bound by the representations made before the main contract was signed. Now, we as lawyers, we have a challenge. We have a challenge that there's no way of knowing the type of boilerplate that will arise in future. But my warning always, it is unsafe. It is very unsafe to include any standard set of boilerplates in your contract without considering whether they are appropriate for the particular transactions. One time, I want to emphasize, don't include any type of boilerplate in your contract without considering whether they are appropriate for the particular transactions. So in summary, we can say that these boilerplate clauses serve two main functions. First, they can help to clarify the rights and obligations of the party, for instance, force majeure, assignment, and waiver, and to specify how the agreement will operate, like law and jurisdiction, dispute resolution, definitions, interpretations, and notices. Now, which boilerplates are more important than the others. When I was in BP as general counsel, those working with me often ask this question: which boilerplates are more important than the others? And anytime I'm asked that question, I remember when I was taught in the university that a lawyer should not give a direct answer. A lawyer should just say, it depends. And I find this helpful, that if you ask me a question that I do not want to commit myself, I will simply say, it depends. Now, if you are in Nigeria today and you have cause to draft a contract, and the contract to be performed in Zamfara State, Niger State, Katsina State, Kaduna State, and some of the states in the south, you know that you must provide for force majeure. As you see shortly, if you do not provide for force majeure, the contract may be frustrated. The consequences arising from frustration are not the same as those arising from force majeure. So my advice is you should provide for force majeure. Force majeure has its own problems that we will address shortly in this presentation. Now, when you are negotiating a contract, you may find that you have very simple boilerplate provisions, or very light, or very medium, or full scale boilerplate. So there's no general legal requirement for this. For instance, if you look at the contract, typical structure of a contract, you'll find type of contract, commencement, parties, recitals, definitions, the commercial obligations. Then you have all these boilerplate clauses. There's no particular order, but you find them, like I said, you find them in almost every contract. So in examining boilerplate, our focus will be, I keep saying, the purpose of the clause. What purpose does the clause serve in a contract? Where we have a problem as lawyers is the drafting issues. You see, what you find in practice, when you leave university, leave law school, and you come, you are working in a law firm, you have to go and draft a contract. You're giving a precedent. But that's what they do. They all go to their file, they drafted a similar contract before, or if there's not in their file, they say, you go around, call your colleagues in other law offices. They should send you a precedent. For me, that is not a way to go about it. You need to attend programs like this to know why a particular clause should be in a contract. And if it must be in a contract, what drafting issues will arise? And this particular clause, where should it be in a contract? And what is the linkage between the clause and other sections or parts of the contract? Then there are several precedents that can be examined. Let's start with force majeure, because for me, I think it's the baba of them all. Is the one that creates. Just now is a major issue. And you know, when parties enter into a contract, the intention is that they will perform all their obligations. That is the intention. But where it is impossible to perform their obligations or perform the obligations in a manner substantially different from what they had intended, or there are factors beyond the control of either party, or there are events reasonably unforeseeable and they occur, what will happen to that contract? Under common law rule, that contract is frustrated. Now, we know the problem with frustration. You remember your law of contract that loss lies where it falls. That's it. But if you are clever enough to pretend frustration operates by comes to force by operation of law, but force majeure does not come into force by operation of law, you must provide for it. So that is why, for me, like I said, you must provide for it. And one of the reasons you must provide for it is that you must define what constitutes force majeure. What constitutes force majeure? And in my experience, one major issue that parties hardly agree on is industrial dispute. Force majeure. Now, when you are drafting, in some contracts, force majeure effects are atomized. Is that necessary? Do you need to atomize the force majeure effect? In other words, should it be closed-ended or open-ended? Now, what happens where a party to the contract is responsible for the force majeure? What happens? What are the consequences? Like I said earlier, if it's frustration, laws lie where it falls. But if you can properly draft your force majeure clause, you find that if you have made some investment before the force majeure event, you may be able to recoup your investment. So let's look at the drafting issues. First, like I said, the definitions. What are the consequences? What is the procedure to be adopted? Now, I find that we as lawyers, if there's a breach of contract, we're very quick at termination. For me, it's not the best approach. Now, there's what we call cure period. Cure period. So what you should provide for in a contract is that if there is a defect or a default, instead of terminating, you give notice of your intention to terminate. Notice of intention to terminate. And if the contract is properly drafted, there should be a cure period. For example, you find that a party should be given 3 months or 6 months to remedy the default, to remedy the defect. That's the cure period. So it is when the default cannot be remedied during the cure period that you go to the next level of actually terminating. Now, so it's a device that I use severally and it worked for me. So when there's a breach, don't just terminate. Give notice of, again, it depends on how the contract is drafted. So if the contract is drafted that once there's a breach, you terminate, you don't have a choice. But if you are involved in the drafting, don't terminate because of a default. The default can be remedied if there is provision for a cure period in a contract. Now, where is the location of this clause? When is the location? Now, it's usually among the commercial obligations and is connected with performance and payment obligations. Now, the president. This is one reason why this committee has not taken up before now. For instance, if we had a physical session for this presentation at this level, we will go practical. We will give assignments to participants to actually draft a precedent in the short form, draft a precedent in the medium form, draft a precedent in the full form. But for a virtual training like this, all you can just read in the screen the forms of force majeure. But we are hoping that very soon we will be able to have physical in-person training where we will have real exercises. It's very important to me as a teacher instead of teaching precedents. But there are textbooks that have this standard precedent. In fact, I have a book that has a CD, and the CD has this precedent. So when I'm drafting, I just go to the CD and lift whatever precedent I want to use. So some people think that some of us are magicians in drafting these courses. That's not correct. Not correct. Because we have the materials, we have the books, we have the precedents. So these are the precedents of force majeure. Well, like I said earlier, it could be that the parties will agree on the definition. And it's generally an event outside the control of the parties, not foreseeable, not foreseeable, not foreseeable, and no party is at fault. It must not be foreseeable. If it's foreseeable, then it cannot be a force majeure. I remember once there was this transaction in, I think, Yobe State. I think one of the discos or the Gencos was sold. And when the investor could not perform, the investor said it was force majeure. And what was the force majeure? Boko Haram. By the time the contract was signed, a state of emergency had already been declared in the area. A state of emergency had already been declared in the area. So you cannot say that it's an event that will enable you to book. So you mind how you advise your clients in this area. Even if you decide to adopt the long form where you list all conceivable events that can amount to force majeure, ensure that you just state that it is not limited, it includes but not limited to the following. So make it open-ended, but again, remember your using generis rule. So make sure that you draft very, very intelligently. And, you know, when you list events and you didn't list others, don't forget the magazine, especially unus est exclusio alteros. Don't forget the magazine. Now, cumulative remedy. This is one device that I use a lot during my days in BPE. You know, when you are drafting a contract, you can provide for remedies in that contract, But unless you have this cumulative remedy in your contract, it could be taken to mean that the only remedy available to the parties are those in that contract. So what this clause does is to say that in addition to the general remedies available under the law, these are the remedies in this contract. I take that again, that this contract is not limited to the remedies available in this contract. The contract is subject to the remedy available under the general law. It's very, very important so that nobody is cheated. Nobody will assume that, because the contract provides for remedies, you cannot benefit from the general law. Now, the drafting issue always is whether you say it's cumulative or in addition. And it's usually found in the boilerplate section, and it's linked to termination provisions and entire agreement. Now, again, here, I give the precedence of the type of contracts we are talking about. Entire agreement. I referred to this earlier, and I find it very, very effective in reviewing a contract. So if you ask me to write a legal opinion for you in terms of a contract, once I have the document, I will just check whether this heading is there, whether there's any entire agreement clause. What it does, you are saying that this document forms the entire agreement. All representations made, all the pre-contractual documents signed, MOU, letter of agreement, letter of intent, all the pre-contractual documents signed prior to the execution of this agreement are not applicable. So this document represents the entire agreement. And I use it a lot. It can work for or against, but be careful that when you're migrating from the pre-contractual document to the main document, you ensure that all the critical elements of the pre-contractual agreement are captured in the main agreement. Now, what are the drafting issues you are going to face in this area? What are the drafting issues? Now, this is whether the agreement is to be limited only to its written terms or reliance can be based on previous course of business. So can you say parties will rely on the written terms, or if they have been dealing with themselves before, they're going to rely on cost of dealings? These are the things that you have to address. And the location, usually in the boilerplate section, it is linked with representation of costs and warranties. Now, you must be careful, like I said, you must be careful in using any of these clauses. You'll be amazed that a matter will go to court for the purpose of interpreting one of these clauses. I have given precedence here again, like I said, it's a pity I cannot. Now, this paper is in PowerPoint here, but there's a full paper which will be available to all those who are taking part. So when you get the full paper, you should be able to examine all these precedents. I may not have time to examine all the precedents now. Further assurance. When a man buys a Porsche car for a lady with the intention of marrying her and fails to marry her, does the lady need a further assurance? I'm not talking about Chioma and Davido. So does Chioma need a further assurance now? That's by the wayside. Let's get out of business. Now, when you are dealing with government departments, for instance, you buy a Genco or you buy a Disco, that is just a contract between you and BPE, for instance. There is just a contract between you and BPE, for instance. Now, to operate the Disco or the Genco, you need a license for the Nigerian Electricity Regulatory Commission. So when you buy the asset from BPE, you include this clause that when you apply to NEC for your license, BPE will assist you to obtain the license. That's how it works. So there are assurances in the contract. You are saying that in addition to the assurances, I will need further assurance in case we have to.
will come right away.
In case we. What's going on? Hello?
Yes, sir,
Hello?
you can go ahead. You can go ahead. I had to
Okay.
mute everyone, sir.
Okay,
Sorry.
okay. So you include this clause in a contract to avoid any argument. You know, government, once you sell and they collect money, they will ignore you. They will ignore you. So just ensure that at the point of negotiation, you have this further assurance in the contract. And if you go to NEC, for instance, and NEC is giving you a problem, you go back to BPE. BPE, use your offices to, or BPE can get back to the VP, who is the chairman of National Council of Privatization, to say, look, Minister of Power, call chairman of NEC to give this investor the license. It's very, very important where you need a further instrument to do your transaction. So here, something is happening. Okay, let's look at the drafting issues. Should it be a simple clause or a more detailed clause? Should it be a simple clause? It depends. It depends on the type of assurances that are in the main contract. It depends. Then usually found in the boilerplate section and usually linked with the formal assignment of the contract, innovation agreement, licenses, and all that. Again, there are the precedents here that you can look at your own time. Commencement date. Now, when I'm drafting, I like to draw a line between commencement date, execution date, and effective date. Unless these terms are carefully defined, they create problems of interpretation. Now, when is commencement date the same thing as execution date? Now, sometimes you enter into a contract and the contract is signed. In the signed contract, there are several conditions precedent. Like the example I gave now. The investor buys a Genco. Then that purchase is subject to license from NEC. Now, can that contract be effective without the license from NEC? So it's important that commencement date is carefully defined. Execution date for me is simply the date the contract is signed. When I was in BPE, there are several contracts that we signed for over a year. They are not effective because the conditions precedent have not been fulfilled. What you normally have in the contract is, unless the conditions precedent are fulfilled or they are waived. So if they are not fulfilled or waived, that contract cannot be effective unless they are fulfilled, even if that contract has been signed. So the drafting issue, like I said here, is the difference between commencement, execution, and effective date. So you have to be very careful in drafting a contract and define the words very carefully. Now, like I said earlier, in every contract, you will have a commencement date. And it's usually at the beginning. Now, there are some contracts that have obligations that may arise at different times that belong to different parts or different sections of the contract. So if there are such obligations that arise differently, then provide for them differently and provide for when they can be effective. Acknowledgement. One area I find is very, very important for us as lawyers is, remember our statute of limitation. That for a simple contract, if not enforced within 6 years, or a specialty contract, if not enforced in 12 years, it becomes statute barred. Acknowledgement is one way of reviving the contract. So if you pick any set of limitations, that of Abuja and that of the various states, you find that there are elaborate provisions on acknowledgement. So please bear that in mind. Now, I said earlier, we have over 70 boilerplate clauses. So I'll quickly just mention this because somebody said to me, how can I deliver this lecture in 1 hour? And I said, I will try. Agency and partnership. Because we are in partnership, does that mean that I'm your agent? You know, agency can be created in all kinds of funny ways. It can be implied. So if you are in a partnership, have a clause that the other party is not your agent. Assignment, innovation, subcontracting. These are very, very strong clauses that you should provide for in your contract. Like I asked at the beginning, should a party have the right to assign its rights and obligations to another party without the consent of the party to the contract? Should the party be? No. So unless it's a contract of a personal nature, or that has statutory limitations, such a contract can be assigned. Otherwise, a contract can be assigned. Now, where you now make the third party a party to the contract, he signs the contract, that is innovation. When you authorize one particular party to subcontract its obligations under the contract, that is subcontracting. Completion or closing. We call it completion, the Americans call it closing. This is very important. For instance, when I was in BPE, we were doing a lot of share sale agreements. You know, if you enter into that agreement, share sale agreement, you find that the investor is merely buying the shares of the federal government. But BPE that was selling the shares is not the company. It is not the company that owns them. So After signing the agreement, you will fix a date for completion. That is a day, there will be a board meeting to pass a resolution transferring the shares and ensuring that your name is in the register of members. Unless that happens, the agreement you sign that sold shares to you is useless unless you are a member of the company. And the way of becoming a member for this purpose is that the board of directors will pass a resolution transferring the shares to you and ensuring that your name is in the register of members. Severance and invalidity. Sometimes, no matter how careful in drafting, you find that there will be some clauses that are invalid. So what the customer will do is, okay, can we just take out these invalid parts and see whether the contract can still function? If it's possible, the cost will severe the parts that are invalid to give life to the main contract. Sovereign immunity, I find this very, very interesting. I find this very, very interesting, especially in relation to our Chinese contract. A while ago, the Minister of Transportation was almost mobbed by Nigerians for this purpose. And as a law student, I remember that as far back as 1977, there's a case referred to as Trendex and CBN. Trendex and CBN. If you recall, there is a case involving our cement armada. Federal government bought cement to build army barracks, and federal government defaulted in paying for the cement. When they were sued in the UK, federal government claimed sovereign immunity. Sovereign immunity. Remember this magazine, par imperium, non habet imperium, an equal has no power over an equal. In other words, no sovereign state has power over another sovereign state. So the UK government and the courts do not have jurisdiction over Nigerian matters. But you know that in international law, we draw a line between pure governmental transactions, and a commercial transaction. So the court of appeal in England heard that, look, purchase of cement is not a sovereign act, and so Nigeria was liable. So when I take it down to what is happening now, when people were arguing that the railways concession in Nigeria are sovereign act and they were after the minister, I just fell for the minister. What is sovereign in buying coaches for a railway? What is sovereign? It's a commercial transaction. So if you make all such acts sovereign, then no foreign country will trade. No foreign country will do business. So we must draw a line between a pure governmental transactions and a real act of government, the real act of a sovereign. Then notices in a contract you must provide, because the definition of parties at the commencement is not comprehensive enough. So other notices you must provide clearly for how notices are to be served. Lastly, dispute resolution. Dispute resolution. Now, we have to be very careful with this clause. You know, what I find interesting these days is every lawyer is an arbitrator. Every lawyer can draft a dispute resolution clause. It makes me laugh. Make me laugh. Look at our P&ID. One reason the arbitration had issues with us was the use of the word venue for arbitration. Because the clause, Article 20 of the gas sale agreement provides that if there is a dispute, Nigerian law is the governing law, no problem with that. The rules will be arbitration, conciliation rules, no problem with that. Now, they don't use words like venue of arbitration. Now, in arbitration, there's nothing like venue of arbitration. If you look at the Constitutional Modern Law and Section 16 of our Arbitration and Conciliation Act refers to place of arbitration. Place of arbitration. Over the years, place of arbitration, arbitration to mean the seat of arbitration. Now, this P and ID contract, when they started negotiations, they entered into an MOU first. In the MOU, you see, what the guys did, they had P and ID BVI Limited, P and ID Nigeria Limited. In the MOU that was signed, P and ID Nigeria Limited was used. P and ID Nigeria Limited was used. But in the main contract, they used P and ID BVI. That made it international. And that made the issue of seat very, very important. Very, very important. Whereas if they had used P and ID Nigeria Limited, this grammar we're talking about here in the UK and other, we don't know what is it. So for me, it was a drafting issue. Instead of saying place of arbitration, Nigeria, then venue for hearing can be anywhere. And in fact, in some arbitrations, there may be no hearing at the place, but the place is very critical because it's the seat, is the juridical seat, is the seat that ties the arbitration to a particular legal system, so that if there's cause to determine whether the contract is valid, if there's an award is given, whether it can be set aside, is the seat that determines it. So it's very, very critical. So I ought just to be very careful in drafting these courses. One of our resource persons that will be a speaker in this session, Professor Emilia Onyema of SOAS, University of London, will address us on the issue of drafting. If I see, when you mention things like drafting, arbitration clauses, you know, we lawyers are very arrogant. So what is in drafting? What's in drafting? What's in drafting? I always laugh. You will see that there are small things that you do not know or you will never advise your mind to, that will become obvious if you attend sessions like this. Like, for instance, today's boilerplate, I mean, SADA clauses. I mean, we all know about SADA clauses. You know, we are very arrogant. We know about SADA clauses. But how many have you drafted? How many have you seen? Have you gone to court for purposes of interpretation a clause? So we should take programs like this very serious. Then other terms, affiliates. I get back to P&ID again. In the P&ID MOU, the word affiliate was used. Affiliate are entities, for instance, when you have a group structure, all the companies in the group structure, they are usually referred to as affiliates. But CAMA has no provision on affiliates. So in the P&ID MOU, affiliate was used. Affiliate was defined as entities connected with the parties of the contract. Now look at it. The MOU was signed by P&ID Limited and Ministry of Petroleum Resources. Now, what are the affiliates of Ministry of Petroleum Resources? What are the affiliates? So when they were going to sign the main contract, because the affiliates, the MOU has a clause on assignment, has a clause on affiliates, they opted to use the P&ID BVI. P&ID BVI is an affiliate of BVI Nigeria, of P&ID Nigeria, and the contract provided for assignment. So it's very interesting. It's very interesting. Now, terms like, I don't know how much time I have, best endeavors, reasonable endeavors. My advice always, don't use these terms in your contract. Best endeavor, there are arguments as to whether best endeavor is stronger than reasonable endeavor. What is the meaning of forthwith? What is it? You find several court decisions on this issue, the meaning of this. So why do you expose your draft to the cost to interpret? So say exactly what you intend to achieve. Say exactly what you intend. I'm going very fast now because I think I'm talking too much. I need to create time for Q&A so that we all can benefit from what I've been saying. All I'm saying here is don't use best ever. Don't you say exactly what you want to say. Then with time, what is the meaning of forthwith? It means that you say exactly what you intend to say, and I will conclude. When I'm negotiating a contract, I will never accept that there's a starter clause. Never, never. I will always argue that that clause has drafting issues that we must address. And I will never accept a clause until I am convinced of the purpose of the clause in the contract, and that what we are considering, I will be able to address the drafting issues and look at the location of the clause in the contract and see how it relates to other clauses in the contract. Now, it's a pity I couldn't take us through the precedents, but I'm hoping that when you get the detailed paper, you see the various samples that I have provided. They can be short, they can be medium, they can be long. Now, I still stress, no lawyer should accept a standard clause, whether it is called a standard clause, whether it is called lawyer's jargon, whether it is called a boilerplate. No lawyer should accept such clauses hook, line, and sinker. There's a need to consider the suitability of each clause to a particular situation and the potential consequences of including or not including the clause. Thank you very much for your attention, and God bless.
I'm clapping for you, Prof. I hope you can hear me. Brilliant, powerful, characteristically powerful.
Thank you.
Let me unmute myself so I don't interrupt the MC.
Thank you, Prof, for this edifying information and great wealth of knowledge garnered today. Distinguished participants, please make use of the chat box and have your questions and perhaps comments. Thank you. We have scrolled through and do not see any question. So please have your questions on the platform, or would you want to state it? Would you want to be beckoned on so you speak? If you'd want to, then please just use the icon, the chat icon, and then we'll unmute you.
Well, if you teach and there's no question,
we can see a hand.
Okay, all right.
Hand up now. So it
right.
has been a rewarding and an awesome opportunity to hear you, Prof, speak again today. Many thanks for this rich discussion. So I'll just, at this juncture, let me call on Mr. Ogunti to unmute, and then to unmute the participants who want to speak to you directly, Prof.
Okay.
Mr. Ogunti, are you here? Sam? Okay, it appears he's not online at the moment. I'll just go ahead. I can see
Okay.
Isaac Opeyemi.
Ishak Opeyemi.
Ishak Opeyemi, please go ahead. I've unmuted you.
Okay. Thank you very much, Prof. Really appreciate the rich lecture you've given to us today. So I want us to make a clarification on certain things that I don't understand very well. Please, can you please expatiate better on venue of hearing, place of arbitration, and seat of arbitration? What are the distinguishing factors among those three terms? Thank you, sir.
Okay. Any other question?
It doesn't seem to be.
Any other question?
No other person have indicated interest. So
okay, let me if you look at section 16 of the Arbitration and Conciliation Act, it provides that subject to the agreement of the parties, the arbitral tribunal shall determine the place of arbitration, and that the tribunal can have the hearing from place to place. In other words, place of arbitration is different from venue of hearing. Place of arbitration is different from venue of hearing. For instance, I've had an arbitration where the place of arbitration is Abuja, Nigeria, but we had a hearing in Canada. I've done another one where we had a hearing in Singapore. Seat of arbitration is in Nigeria. So the word used by uncitral by most laws is place. The word there, place, is confusing. What is actually intended is seat. That is why if you find the new draft of the bill on arbitration and mediation now before the National Assembly, we did not use the word place. We use the word seat of arbitration and venue for hearing. But if you read text written by various writers on the ancestral model law, you find that by place, reference is to seat. The problem we have had with our own Arbitration and Conciliation Act is that, before 1988, that we had the Arbitration and Conciliation Decree, we had an arbitration law that you will not find things like place. But the ancestral modern law was first drafted in 1985 and introduced place of arbitration. I think in drafting our own law in 1988, we picked place from the ancestral and inserted it in ours. In a domestic reference, like I said earlier, the issue of place is relevant because it's Nigeria. So it can be Lagos, it can be Abuja, it can be anywhere. But once it is international, the issue of place or seat becomes very, very critical. The parties must determine the seat, the juridical seat, because that is the seat that ties the arbitration. That is why, for instance, in the P&ID arbitration, when they gave an award against Nigeria, we went to Nigerian court to set aside the award. Our court actually did, but they were laughing at us because an award can only be set aside at the seat. And that is why for international commercial arbitration, it creates problem as to whether an award set aside at the seat can be enforced anywhere else in the world. It's an issue for another day. So let me put it again. Place and seat, they mean the same thing. Place and seat, they mean the same thing. What is different is the venue for hearing. Now, you can have a contract that provides that place of arbitration is Abuja, Nigeria, right? Because it is parties that bear the cost of arbitration. It's the parties. When you find that almost all the witnesses are in Europe, you are probably the only party appointed arbitrator in Nigeria. The parties will find that it's cheaper for them to have the hearing in Europe. It's cheaper for just you to leave Nigeria for Europe than for about 10 people to leave Europe for Nigeria, because it's the parties that bears the cost. But once you ensure that in the contract, the governing law is Nigerian law. So whether the hearing is in Europe or in Nigeria, as to the merit of the case, international commercial arbitration is very funny. You find that in one contract, 5 different laws can govern it. 5 different laws. For instance, the law governing the capacity to contract is determined by your individual law. Then, because of the principle of autonomy of the clause, that we often refer to as the principle of separability, i.e., if you look at section 12, sub 2 of our act, it says when you draft a contract that has a clause on arbitration, that clause on arbitration is independent of the contract, and therefore, even where the main contract is null and void, that clause suffices. So the law governing the merit may be different from the law governing the clause of arbitration. Then if the hearing is in another place, the law of that hearing, then enforcement, if you try to enforce, if the parties are, if they are, one of the parties is a party to the New York Convention, then the issue of the law of the place of enforcement will arise. So as you move from domestic to international, it gets more complex. But I'm saying that place it's not an issue in the domestic reference, but for international arbitration, it's a major issue. I hope I've cleared your doubt.
Yeah, thank you very
I
much.
can see Max raising his hand. Okay. Are you all right, Isaac? Isiak?
Yes, sir.
Okay.
I'm well clear, sir. Thank you, sir.
Yes, moderator. Okay. I can see Max raising his hand. Can someone unmute Max, please?
Hello.
Okay.
Okay.
Max,
Hello,
you can
Prof.
speak
Can
now.
you hear me, sir?
Yes. Okay. Max can speak now.
Okay. Thank you very much, Prof. And very excellent presentation. Once I saw the adverts for the program, I was really excited. So, Prof, my question: two boilerplate clauses I want you to throw some light on.
Yeah.
Representations and warranties, particularly the effect where a representation is actually found out to be false, but the contract clearly states that, look, I'm not representing to you ABC, but it's found out later after a breach that ABC is false. What is the impact? Then secondly, the no partnership clause, that this agreement does not constitute the parties to be a partnership or a joint venture.
Yeah.
Could you give some more light on it and circumstances where it will not be desirable to use that? Thank you, sir.
Okay. We are going back to our law of contract in university now. Representations are statements made to induce you to enter into a contract. Statements made to induce you to get you to enter into a contract. Now, they may be false, it may be fraudulent, and there's a right, there's a remedy for you if they are false, if they are fraudulent. Now, when it comes to warranty, these are now statements you made in a contract proper. For instance, you warranted that your company was properly registered with CAP, blah, 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 blah. The point I'm making is when you are considering entire agreement clause, it deals with whether representations made before the contract was entered into, but not captured in the main contract, are part of the contract. If you draft the entire agreement clause properly, it means that that document and document only represents the entire agreement of the parties. You cannot go back to representations made that induce you to enter it. Now, on no partnership, like I said, agency is very funny. There are various ways of creating agency, it can be implied. So to avoid, because one is your partner, to avoid a situation where agency relationship can be implied, you said in the agreement that, look, we are not agents of the others, we are partners, except expressly authorized, no partner can bind the company. I hope I've answered you, Max.
Thank you very much, Prof.
Okay.
Thank you very much, Prof. We from the chat box, we have some questions posed, but I'll start with the question from, we have a question from Victoria Balagbobo. My apologies if I didn't get that right. Our question is, sir, kindly distinguish between assignment, novation, and subcontracting again. Thank you, sir.
Okay. Right. Like I said, when parties enter into a contract, there are several obligations on both parties. The question is, can such obligations be transferred to a third party? I said, if there are obligations of a personal nature, they cannot. But parties can have a clause on assignment where they agree that either party can transfer their obligations under this contract. Just the two of them agreeing. But where the parties agree that a third party who was not a party to the contract can now have rights and obligations under the contract, and the contract will now be signed by 3 parties. That is novation. But let's go back to the contract between the 2 parties. The contract between the 2 parties can expressly provide that party A can assign its responsibilities under the contract to party D or party F, as the case may be. That is subcontracting, that one party can transfer its responsibilities under the contract to a 3rd party. That is subcontracting. Thank you very much. I can see, okay. I can see Tobe. Can you please, somebody unmute Tobe before I'm sacked? Can somebody unmute the national chair of continuing legal education? Tobe?
Okay, he's been unmuted. Mr. Paul, okay. You're welcome, sir.
Thank you very much. Good afternoon, Prof. Good afternoon, delegates. Unfortunately, today we had another training going on, so I had to jump from here to there, and hopefully we wouldn't have such clashes in the future. I had the privilege of going through Prof's paper, and I found it quite illuminating. I guess that was the reason why I felt, well, I don't have to come for the whole session. But even the bits that I've listened to, I found them very illuminating. Prof, congratulations. I think it's a very timely topic. I think that contracts and contract drafting is something that every lawyer should take very seriously. And I would say that perhaps because in Nigeria, professional negligence is not a big issue as yet. Most people just draft contracts for the sake of it and don't really think about the true import of the written word and what a lawyer puts his name to. But as the world gets globalized and we continue to integrate further, you will find that people cannot get away from some of the things that we do now. So, Prof, I found the bit that I've listened to quite illuminating and interesting, especially the questions that are coming through. I congratulate you at Abuja branch, and I congratulate the ESCO of the branch for this very laudable initiative. I'm impressed. I'm happy. Thank you very much for what you do. And hopefully, as we move forward, we'll be able to push the frontiers of knowledge and add value to our members across Nigeria. Thank you very much. And thank you for all your cooperation and guidance, Prof. Thank you. Grateful.
Thank you very much. For your information, Tobena Erojikwe is the chairman, NBA Institute of Continuing Legal Education. He gave us the accreditation to have this seminar and to ensure that all the participants will earn their credit. So on behalf of the chairperson, let me publicly thank you for being so warm towards us and for having our listening ear. Thank you very much. Except if the chair wants to say something, the chair? The chair? I think she's not
yes,
there. Maybe later. Okay, I want to talk to Tobe. Okay.
Yes,
okay.
Just to appreciate him, the chair of the Institute of Continuing Legal Education of the NBA. So we're very delighted and very happy to have you join us in spite of your very, very hectic and busy schedule. I know that there was this other training, and I take the hints. Next time, before we schedule, we'll make sure that we will compare notes and make sure that there are no clashes. The second training of the CLE is scheduled for 27th of March. We'll follow up with Sarah to ensure that it doesn't clash with any other training that you have. I want to thank you so much once again for your leadership and for the support. We're so happy about this. This is our first outing through the CLE committee. And I'm so glad that most of our members are so happy to be part of this training. Thank you, sir, and all the best.
Thank you. Thank you very much for your very kind words. Thank you very much, Prof, for your kindness to me and to the board of the Institute of Continuing Legal Education. I hope that as time goes forward, we'll keep exchanging ideas. And truly, at the end of it, I just want to say to all our members that are here that on behalf of the president of the MBA, we just think that there's a lot that's wrong with our profession. And our interest is really to bring value to our members. And one of the greatest ways of bringing value is through capacity building and development. When a lawyer goes to gain knowledge, what he's getting is he's getting the goods that he's going to sell in the market, because we are all knowledge merchants. So I encourage us to think more positively about what would be most beneficial to our members at all times. So thank you very much, and it's been my pleasure joining you today. Thank you.
Thank you, Mr. Tobina Erojikwe. We are grateful for your presence once more. We are humbled indeed, and we look forward to your collaborating with us and also joining us in our subsequent trainings. And so far, so good. We started the program 2 p.m. Okay, I hand over to our co-moderator.
Okay, we have an eagle in the on the training today in the person of Emilia Onyema. I don't know, Prof. She says, except you wish to make her have her own interventions, that she will be silent. So I don't know. Would you want to speak?
Let Emilia speak. Tell her to speak. Tell her to speak.
Okay.
Emilia, speak.
Prof, good afternoon. Good afternoon, everybody. I'm just wondering, I think, so to say a huge thank you for the paper and for your discussions. Yeah, I'm just wondering, what do you want me to what do you want me to say? Do you want me to answer a question? Do you want me to contribute? I'm quite happy just listening and learning.
Make your contribution to the topic.
Okay, I think you've said almost everything that needs to be said. Where I may want to just sort of maybe say something around the seat, the distinction about venue, place, and seat, and maybe just to re-emphasize the importance of ensuring that there is clarity to it. And noting that in our own jurisdiction here in the UK, we've actually gone beyond just making sure that you clarify where the seat of your arbitration is. We've gone so far with current case law here, it's become really important to also expressly state the law that governs your arbitration agreement. And so because the courts here have, on the basis of contract interpretation, we're now, so before we had our Halliburton and Chop decision, it was a question of the seat of arbitration had the closest connection. And so the most important thing we would say to students is just make sure that at the very minimum, you have identified the seat of your arbitration. But clearly, depending on how your arbitration clause is drafted, the law of your substantive agreement, so the law that governs the underlying transaction, the underlying contract, would then also govern the arbitration, your arbitration clause. And then that becomes, in other words, what's the relevance of your seat? And so it's massively important. I think that it's important to just keep that in view. So the seat is massively important as per the legal seat, because that is what will make the difference, a major difference, as Prof has said. But we need to go beyond that and identify the law that governs your arbitration clause. So don't leave it to chance. And if you're clear what law you want to govern your arbitration clause, so especially if you want it to be a different law from the law that governs the substantive contract, then to please ensure that you include that. The second thing I would like to just sort of quickly mention goes to Max's question on representations. And to say that for us here, it's not too much on warranties. is that it's not too much of a problem, because of course, if you go back to Pakistan and Dala, Pakistan v. Dala, the major consideration for us here is that if it's not in the contract, it's not part of the contract, because we have a Misrepresentation Act. And so everything pre the contract falls under the Misrepresentation Act. But if it is not part of the contract, it is not. So if it's not in the contract, it's not part of the contract. Unlike French law, that would look at the circumstance, the drafting history, how you got there, blah, 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 and pull all of that into the interpretation of the contract. And then the last thing to say as it relates to warranties is just to remind us to be careful with insurance, because of course, under insurance contracts, a warranty has the same value as a contractual condition. The status of the term is not just a mere warranty, it is a condition of the contract. And so to be careful that different types of contracts may define similar words differently. And so I think the key thing that Prof has left us with, which I think I would strongly encourage us, is when drafting, say what you mean. Be very, very clear. If it is limited, limit it, because of course we can't foresee everything. And so if it is limited, the intention, just make it as clear as you possibly can. Remembering that we as arbitrators and the courts, what they do is we interpret the contract. We try as much as we can to be objective, asking ourselves, what was the objective intention of the parties on the day when they drafted the contract, when they agreed the terms? Okay, don't forget that we ask that, but we have hindsight because we know what has happened in between. So if you don't want somebody else to begin to tell you what you had in mind 10 years ago, 5 years ago, even 12 months ago, when you drafted that contract, just make it really, really clear. I don't think there's anything else I can add. So except to say thank you very much for the opportunity to contribute.
Yes, thank you, Emilia. Like I said, in July, Emilia will be speaking to us on this platform. So she's already expressed willingness to. She's based in the UK, like I said. She's a professor of international law at SOAS, University of London. So she's already expressed our willingness to participate in this program. So just get your powder ready so that when she comes, you can just bombard her with questions. Thank you, Emilia.
Thank you so much, Prof, and thank you, Emilia, for this interesting and outstanding presentation. With the kind permission of the chairman of the committee chair, may I at this juncture call on a member of the committee, Continuing Legal Education, and the person of Professor Akinseye Judge to recapitulate this discourse and give the closing remarks. Janet Six, sir.
Yes, thank you very much. It's been a wonderful time, and it's been an enlightening period. The distinguished Professor Paul Idonige, I believe, has done an excellent job, and we have been significantly, enriched significantly, So the only thing I want to say is that we deeply appreciate him. I want to thank all those who have asked questions. I want to encourage us in the future to come early, because Prof had to wait for us. When we started, only 2 or 3 of us were there. The majority of our members were not there. I understand that we were quite busy, but when we have agreed to have a workshop, please, in future, let us all attend to it promptly. And then there was a suggestion that people came late because the lecture is free. They didn't have to pay registration fees, but the chairman quickly pleaded, the chairman of the bar, of the branch, quickly pleaded that, maybe this is because it's our first outing. So I want to encourage us in our subsequent outings to be prompt so that we can, make the most of the time assigned for these trainings. Thank you very much. Thank you for the opportunity to say a word. Thank you.
Thank you, Leonard Silk. We really do appreciate you for staying from the beginning to this point. We do hope this dialogue has sufficiently discharged the essence of this focus today. The certificates will be made available in no time, and same will be posted on all the platforms accordingly. Again, we appreciate our speaker, distinguished gentlemen of this noble profession, the executives of the National Committee on Continuing Legal Education, the executives of the branch, members of the Committee, Continuing Legal Education, who collectively put together this webinar, and the rapporteur, BJ Bulama, and all who joined in this webinar today. We appreciate you for your time and cooperation to the success of this training. This is to reiterate that there will be a second training on this topic, on this committee, named, I think, Negotiating and Drafting Community Development Agreements. It's scheduled for the 27th of April, 2021, and it will be posted on the platforms as well. It's been a pleasure co-moderating today with Samuel Ogunti, and I remain Chinelo Audrey Ofebunam, the Assistant Secretary of the branch. Thank you so much.
Thank you, Chinelo.
Is the chair not making a closing remark? Yeah, okay.
If she wants to, she's still logged in. So.
I think the chair should make a closing remark. Yeah.
Okay.
Okay. As my professor pleases, I want to thank Professor Paul Idonije, Senior Advocate of Nigeria, for this brilliant lecture. And when I first saw the topic, I said, which one is boilerplate again? And I just couldn't understand what it was. I didn't want to express my naivety. So I said, let me just keep quiet until the day of the training. Then I will unravel what this boilerplate is all about. Unknown to me, it is general, clauses that we all tinker with every now and then when we draft, agreements and contracts. But thank you very much. Sometimes it's good to some of these legalese, some of these words, when we want to show that we are learned, especially when we're dealing with some of the unlearned people, it comes in handy to use such very strong legalese. But thank you very much. Truly, for me, I learned a lot. I don't know about others, but I learned a lot. And so far from the chat messages on the chat box, people have learned a lot from this training. And we look forward to the next training, which would also be very, very enlightening. And I want to encourage us to stay tuned to the next training, which comes up on the 27th of April, subject to confirmation by the Institute of the Continuing Legal Education of the NBA. I want to also use this opportunity to appreciate Professor Emilia Onyema. I was excited when the moderator mentioned that we had Professor Emilia Onyema on the participants list, and I was like, wow, this is a great one for us. We haven't met one-on-one, but I'm one of your friends on LinkedIn. And I'm also an old alumni of SOAS. I did my master's in SOAS. And so it's so nice to connect with you, and we really appreciate your contributions and your support. I'm excited to hear that in July, you'll be taking the center stage to talk to us. I look forward to it. Thank you so much. And I want to thank my learned friends, everyone who has made this training a success. I commend each and every one of you, and thank every participant for all the sacrifice, the commitment, and I pray that we continue to go from strength to strength in our practice and in everything that we do. Thank you very much. You all have a nice evening. Thank you.
Thank you. Thank you.
Thank you, Chinelo. Moderators, you did a great
job. Thank you, Chairman.
Yes, sir.
Thank you.
Thank you, ma. Okay. Bye-bye.
One time.
Chinelo.
Don't
was an excellent MC.
In your contact.
Thank you
very much, Chinelo. Thank you very much. Enjoyed your scene of the event.
Thank you.
So in summary, you can say that these boilerplate sources serve two main.
So I think Chinelo and Samuel, we need to arrange to have the recording and also the slides sent out to our participants. And please reach out to Sarah Ajitola. You have a number because she said she wants names in a particular format. She will let you know so that we can get the CLE certificate for all important than the others.
Okay, ma.
Thank you very much.
Okay, ma. It's actually being broadcasted to YouTube now, so I won't end the.
Yeah, I can hear it. I can hear it on YouTube.
Great.
Next time I'm asking that question, I remember when I was
so people, we can share the YouTube.
The lawyer should not give a direct answer.
Okay.
The lawyer should just say it
okay,
depends.
Ma. Okay, ma.
And I find this helpful.
Just a minute.
Budget and one for 100. That's your new one. Open it now.
Oh, brilliant.
Sarah, this is medical.
And this particular clause, where should it be in a contract? Where should it be in the contract? And what is the linkage between the clause and other sections or parts of the contract? Then there are several precedents that can be examined. Let's start with force majeure. Because for me, I think it's the Baba of them all. Is the Baba of them all, is the one that creates, just now it's a major issue. Just now it's a major issue. And you know, when parties enter into a contract, the intention is that they will perform all their obligations. That is the intention. But where it is impossible to perform their obligations, there are factors beyond the control of either party, or there are events reasonably unforeseeable and they occur. What will happen to that contract? What will happen to that contract? Under common law rule, that contract is frustrated. That contract is frustrated. Now, we know the problem with frustration. Remember your law of contract that loss lies where it falls. That's it. That's it. But if you are clever enough to predict frustration oppressed by comes to force by operation of law, but force majeure does not come into force by operation of law. You must provide for it. So that is why, for me, like I said, you must provide for it. And one of the reasons you must provide for it is that you must define what constitutes force majeure. What constitutes force majeure? And in my experience, one major issue that parties hardly agree on is industrial dispute. It's industrial dispute, force majeure. Now, when you are drafting in some contracts, force majeure effects are atomized. Is that necessary? Do you need to atomize the force majeure effect? In other words, should it be closed-ended or open-ended? Now, what happens where a party to the contract is responsible for the force majeure? What happens? What are the consequences? Like I said earlier, if it's frustration, loss lies where it falls. But if you can properly draft your force majeure clause, you find that if you have made some investment before the force majeure event, you may be able to recoup your investment. So let's look at the drafting issues. First, like I said, the definitions. What are the consequences? What is the procedure to be adopted? Now, I find that we as lawyers, if there's a breach of contract, we are very quick at termination. For me, it's not the best approach. Now, there's what we call cure period. Cure period. So what you should provide for in a contract is that if there is a defect or a default, instead of terminating, you give notice of your intention to terminate. Notice of intention to terminate. And if the contract is properly drafted, there should be a clear period. For example, you find that a party should be given 3 months or 6 months to remedy the default, to remedy the defect. That's the cure period.
Okay,
so
Sam.
It
so
is when
I just sent you
the default cannot be remedied during the cure period that you go to the next
Please
level.
post on your committee
terminated.
platform. And then I've sent it to the secretary as well to post on all the platforms.
And it worked for me. So don't when there's a breach, don't just terminate. Give
thank you.
Again, it depends on how the contract is drafted. So if the contract is drafted that one,
so I'm going to log out now.
You don't have a choice. But if you are involved,
I've given you 5 minutes.
Don't terminate because
this conversation is not recorded.
The default can be remedied if there is provision for a cure period in the contract. Now, where is the
Thank you, everyone still logged in. We really do appreciate
now,
you. The certificates will be posted on the platform when they are ready.
and is connected
Please
with
watch out for the
performance
second
and payment obligation.
training coming up on
Now,
27th. The
President,
flyers will go out as soon as
this is
possible.
one reason why
Thank
this
you,
committee
thank you,
has
thank
not
you.
taken up before now. For instance, if we had a physical session for this presentation,